Okay. So very warm good evening to everyone present here. I welcome you all for the webinar series of Legum Walks. Thank you so much for coming at this time. I hope everyone is safe and sound at their places in these tough times of COVID-19. And for today, the topic for the webinar is Art of Cross-Examination. And we have with us Senior Advocate Sunil Sethi sir, who will be addressing us on the topic and will be explaining all the nuances related to the art of cross-examination. Before beginning, I would like to give a brief introduction about the sir. Mr. Sunil Sethi is a senior practicing advocate in the Supreme Court of India and is based out of New Delhi. Sir has completed his LLB from Jammu University and has been designated as a senior advocate by the Jammu and Kashmir High Court. Sir has also been appointed as the president of Jammu Bar Association. Mr. Sethi is adept in constitutional law, criminal law, arbitrational law, and taxation law. Apart from his sterling individual practice, Sir is the standing counsel of some of the major organizations in the country, such as BCCI, Indian Airlines, and Central Bank of India. And who could have done justice other than Sunil Sethi sir on the topic of art of cross-examination, who is an expert in this particular field. I thank sir who has accepted our offer for coming and presenting the webinar for today. Thank you so much, sir. Now over to you.
Very good evening to all of you. It's an opportunity for me to interact with you people and address you on probably one of the most interesting and important aspect of the trials, particularly when we refer to the criminal trial. So firstly, I'll start with this. What do we understand by criminal trial and how criminal trials are different from other trials? And we can say that civil trials, the trials of the civil cases, are the revenue cases, are even the writ jurisdiction before the constitutional courts, are tribunals and other things where the evidence can be taken, where the evidence will apply. See, let us try to find something very interesting. I think that in all other forms of trials, starting from civil trials, trials of the civil cases and the revenue and other things, see, what is the purpose of the trial? The purpose of the trial is to find that what is right, so that a judgment can be given on something which is right. You have to establish a right of a person. Like if you take a trial of a civil case, say there's a dispute between two persons. A person says that he's the owner of the property, the other person says that he's the owner of the property. Now, what is the dispute? That who actually is the owner of the property. So the evidence will be laid upon this, that whether A is the owner of the property or B is the owner of the property, or who is the intruder of the property. So the court records the evidence and finally come to a conclusion that A or B is the owner of the property, and as such he is entitled for the right. That will happen in every other trial also. But when we move to criminal trial, you will find entirely different aspect taking place, entirely different situation emerging out of it. Because in criminal trial, we are not, it may sound strange to many of you, in criminal trials, we are not concerned that who is the person who has committed the offense. That is the marked difference between the criminal trial and the other forms of litigation or trials. In criminal cases, we are not concerned, our system is not concerned with finding that who has committed the crime. Our system is concerned only about finding whether the investigation which has been done is right or wrong. So basically, the criminal trial works on negative principle, finding out whether the investigation is correct or incorrect. I'll give an example. See, if say in a murder trial, if the trial takes place and the court comes to the conclusion that the accused who's facing the trial has not committed the offense, and the court acquits him, Now, does the court move ahead of this to find that who is the person who has committed the crime, who has committed the murder? No. Our criminal trial system will stop there, finding whether the investigation is proper or not proper, and then we give a judgment whether the person is liable to be acquitted or convicted, and stop there. Now, in all those cases, 60 to 70% cases where the persons get acquitted in trial and maybe more in appeals, what the court is finding is that the investigation which has taken place, investigation which has been done by the police agency or the investigating agency is wrong. The person is not the person who has committed the crime, but it is a matter of fact that the person has died. A person has died in murder trial. If a person has died, who has killed him? We are not trying to find that. Because our system says that we are only concerned about finding whether the investigation which was done by the police was a right investigation or wrong investigation. We don't do that. Court's job is not to investigate. No, same thing will not happen in civil trials. A civil trial will look into this, that who has got the right, who is the owner of the property. Because the system is like that, with the inherent problem in the criminal trial system. So that is the reason we oftenly come to the famous saying that in criminal trials, it is the benefit of doubt which will tilt the scales in favor of the accused. If there is a doubt in the mind of the court that the person may or may not have committed the offense, the benefit goes to the accused. Well, I'll make you understand in a simpler way. In a criminal trial, if the court is not in a position to say with confirmation that the investigation which has been done by the investigating agency was absolutely correct, and the court is still having the doubt in its mind whether the investigation could be a faulty investigation. Now, if the doubt comes in the mind of the court that there may be a possibility of false implication, the benefit will go to the accused only for this reason, because the court will then not be in a position to say with 100% confirmation that the investigation has been done properly, and the benefit goes to the accused. The whole concept of going of the benefit of doubt to the accused is to ensure that in all investigations which have been done, there is no chance of a person getting convicted who actually may or may not have been an accused, unless the court returns or is in a position to return the finding that yes, the person is involved 100% on the basis of investigation where there is no fault. So in criminal trials, the standard of proof is entirely different from the standard of proof in civil trials or other forms of trials. The probability of the evidence, the preponderance of the evidence, will be replaced by the proof of the case without reasonable doubt, beyond reasonable doubt. Now, we come to now from trial system to understand what is the soul of the trial. In criminal trials, we are referring to particularly what is the soul of the trials, criminal trials. The soul of the criminal trials will be the cross-examination. And that is something which is a very interesting part also. Most of you must have seen movies and series on the laws and read the novels also. The most important and interesting part is how to cross-examine a witness. The art of cross-examination is the soul of the criminal trial. But before we start, we have to understand that cross-examination is not a science. Neither it is a formula. It is looking to the probabilities and possibilities. See, when a person who is projected as a witness to prove a fact as per the provisions of the Evidence Act, he will be brought before the court to say that a particular situation he is witness to. Now, whether he is an eyewitness, he's a circumstantial witness, he's a witness to the document, he's coming as an expert witness, but he will be there to state a fact before the court. His statement, which is recorded by the party who is calling him, will be his in chief. We call it in chief, the statement in chief. And then he will be given to the person against whom his statement is supposed to be read. That will be something which is called cross-examination. The most important aspect. Cross-examination will be testing the veracity of the witness. It will be testing whether the witness is saying something which is correct or not, or whether what is said by the witness can be taken up as truth. To draw an inference against the accused person, or draw an inference for the acceptability of the investigation. I give an example to explain that. Maybe 2-3 examples only to explain that. What will be the purpose of cross-examination and how witness is to be evaluated? See, like if we take a case, a criminal case, like a case of abduction. Now, if a person is abducted and after abduction the person is recovered by the police, the person who reported the matter to the police. Say there is a person, he says that he comes to the police station, lodges an FIR, says that my son has been abducted by accused, say X. And thereafter, after the police do the investigation and finally recover the person, the abductee, and brings the person who is the abductor to the trial. Now, the police decides to bring on the evidence the person who has given the report of abduction, who has lodged the FIR on abduction. This person is brought before the court as a witness for prosecution. Once he is examined by the prosecutor, by the police, he will be saying that yes, I have reported the matter to the police. This is a copy of the FIR which has been given by me, and the attending circumstances. Then he will be put to the cross-examination by the accused person. The cross-examination will be testing him. The cross-examination will be testing many aspects. The first aspect will be whether the FIR has been lodged in the manner in which it is projected. A cross-examiner will be testing whether the person has actually lodged the FIR at the same time when it is mentioned, or in the same manner and mode it is mentioned. 2. A cross-examiner will be testing the contents of the FIR, whether the FIR contains genuinely the correct information which the informant had at the time when he reported the matter to the police. Number 3, the cross-examiner will be testing whether the attending circumstances have all been narrated in the FIR. And then the cross-examiner will be testing the veracity of the witness, the character of the witness. Now we'll come to that later on. Character of the witness also. Whether there is a reason of animosity between the witness and the accused person, whether there can be chance of false implication. And then the cross-examiner will also be testing whether the person is saying an exaggerated amount. Maybe some part of it is truth and some part of it is exaggeration, some part is false. So all these things will be tested with the cross-examiner. In the same situation, like the person who is abducted is recovered from a place X, and he has been recovered from place X in presence of another witness, S. Now that person is also brought on the trial. He will come to the court and prove that yes, this person has been recovered by the police in my presence, and after the recovery, the form was made, the recovery form was made, and then this person was brought to the police station and handed over to the father or to the guardian. Now he will come to the court and testify this fact, that he was there with the police at the time when the abductee was recovered. He was there at the time when the abductee was brought to the police station. He was there at the time when the abductee was given to the parents in the custody of the parents. Now these facts he will try to prove. And a cross-examiner will again try to get from him in cross-examination whether the statement or fact he is making before the court is correct or incorrect. There are certain tools in the hands of cross-examiner which comes very handy while cross-examining a person. Now we will briefly refer to those tools also. This topic is a very big topic. What we are discussing, I'll try to make it as concise and try to cover as much situations as we can. Now, the whole justice delivery system in the criminal trials is majorly dependent upon the cross-examination of the witnesses. Please bear that in mind. More than the investigation, more than the prosecution part, more than the arguments part, and more than anything else, the dependency on success of the system is upon the cross-examination. A good cross-examiner will bring the truth before the court. A bad cross-examination will spoil everything, and the correctness or otherwise of the investigation will be shrouded in mystery only. Now, we refer to that what are the tools of the cross-examiner, how the cross-examination should be done, what should be avoided, and what is the manner, if there can be one manner, as I submitted earlier to you, that cross-examination is an art. It is not a science or a formula. So there cannot be a performer of the questions which can be asked in cross-examination. It is because it is looking to the probabilities and possibilities. So each situation will require a different approach to extract the truth from the witness. But before anything else, the one thing without which the cross-examiner cannot do anything is that he should have the mastery of the facts of the case. See, unless a cross-examiner is having absolute mastery on the facts of a case, he will not be in a position to do justice to his assignment, to his job, to his duty towards his client. If you don't know the facts of the case completely, even if you know 99% of the facts of the case, you will not be in a position to do cross-examination. That is what my experience is. And if you know the facts of your case very clearly and in detail, then more than half of your battle is won. While looking to this aspect and moving a step ahead, when a criminal challan or the investigation final report is presented to a court, and the copy of the challan is given to the accused person and to his counsel, the counsel will be looking to the challan very minutely. And please bear with me, a good trial advocate on criminal side will read that brief multiple times to master the case, and also to look for what possibly can be a defense version before you actually start. Now this is step 2. 1, the mastery of the facts, absolutely no doubt about that. Number two, when you read the challan, when you read the police report, the report of accusation against you, you should have a fair idea that what is the parallel story you are looking to probabilize. Now, this is a very vast subject. It comes with a lot of experience. We cover that with the examples. Say, if as a trial lawyer, you get, say, a challan in a murder case, what you will do first is that you will look to the challan, the police final report, that will be given to you under section 173 CRPC. You read that, you study that. You study that to such an extent and with such details that you will feel that now, yes, I have mastered the facts. You have to feel yourself what is happening. Reading will not be sufficient. You have to feel that what the story is being given to you by the investigating agents. And once you start feeling that story, then you will understand that what are the problems in this story. In joining those clues of the problems, you will be having a fair idea. At that time, before the actual trial starts, you will be having a fair idea that what possibly can be a parallel story, a probable parallel story, which can be taken out of this story of the police. Like in a murder trial, if your client is accused of murder, say at a busy market, and the allegation says that you have been seen by 2-3 persons who are cited as a witness, and you are running on a bike after the commission of the crime, you are seen by somebody. Now this story comes to you. In this story, you will try to find out that what are those flaws. Like the market is, say, a one-way market where the traffic is not permitted to go, where it is alleged that you are moving on your bike, like the shops being closed, it is a holiday or whatever the situation may be. But you may be having a fair idea at the start of the trial itself that this is a probable story which you will like to project before them. There are two ways to come out of a criminal trial as a counsel for the accused. We will then refer to some part of it as a prosecutor also. But because most of you will be interested in knowing about the defense side as a cross-examiner, what is the version of a advocate of the accused party. Now, if you draw your story, as I said, from the challan, that yes, this is the story which I will try to build up during trial. Then whole of your trial sequence will be clear before you. Then when you start cross-examination, you will be trying to fill those blanks to probabilize your story, which is in your mind, that yes, this is a probability which I can be highlighting before the court, and which can probably save my client. There are a second option also. The second option, which probably most of the advocates, majority of the advocates follow, that will be hit and trial, as we understand. That there is no story, proper parallel story built up, but an advocate will go, he will cross-examine the witness, he will try to bulldoze the witness, he'll try to contradict the witness.
Hello, Sethi sir. Guys, there was some network issue on sir's end, so sir will be joining with back with us in just one.
Sorry, there was some problem with the network here.
It's okay, sir.
Yeah.
You
So
can
what I
start
was,
your video.
yeah. Uh, so what I was uh, discussing with you was that we have to build up a parallel story before we actually go into the trial. The second aspect what I was discussing was that there is another method which is used by majority of the advocates, that is hit and trial and trying to find the fault so that ultimately they can build a story before the court that there is a doubt in the story of the prosecution, and the benefit of the doubt should come to the accused. But I personally feel that it will be more appropriate, or it is more fruitful, that if a cross-examiner he starts with a parallel story which he will like to project from cross-examination of the witnesses, because in that situation, that part of it, that it is a doubtful story of the prosecution or the benefit of the doubt, is always available to you. Because that will give you a benefit that there will be a system to your cross-examination when you are coming from witness A to witness B to witness C to witness D. You will be having your ideas very clear to you at the time when you go into the trial, so that everything happens more or less as per your agenda, as per your fixation. Now, thirdly, we'll come to what an cross-examiner should not do during the trial. You have to be very clear about this, that a cross-examiner should never ever play to the gallery. That is a mistake most of us do in the trials. We play to the gallery, and that is seriously a very big problem with the cross-examination aspect. If a cross-examiner starts playing to the gallery, he is asking the question only to get appreciation or acknowledgement from the people who are sitting in the gallery. That will be the end of the game. Cross-examination has to be with a purpose. Purposeless cross-examination will do more damage to your client than to the other party. See, what is the purpose of each question? The cross-examiner should know well in advance. Like give an illustration of this. When you are cross-examining a witness, it is said very oftenly that a cross-examiner should have a fair idea that what an answer is going to be to his question. And if he has got no idea what the answer is going to be to the question he's asking, it is better not to ask that question. Because if you have an idea that what can be the answer to the question you are asking, then you will be in a position to lead the witness. You will be in a position to build up your story, which is your basic intent. And if you have absolutely no idea what is coming from the mouth of a witness, or what is likely to be the answer, then it will be too dangerous. Then if you get one wrong answer, which doesn't fit in your line of story, then to cover that, you may have to go for 10 more questions. And then 10 more questions, again, something goes wrong, it will be a very big mess. It will be very difficult to come up with. So next, my advice will be that a cross-examiner should be very clear about what he's asking to the witness and what is likely to be the answer. Don't ask those questions whose answers will not be useful to you. Never ask a question whose answer is not going to be useful to you only for the purpose of playing to the gallery. Cross-examination is not a battle. Please bear in your mind, it is not a fight. It is not a battle where you have to score your point. You have to extract the information from the witness. And that extraction of the witness will be helpful in your building up a story or creating doubt in the story of the prosecution. That is something which every cross-examiner has to understand very formally and very clear. Then we come to another aspect of the cross-examination. A cross-examiner should never exaggerate. Exaggeration is something which kills the cross-examination, the spirit of the cross-examination. Because exaggeration most of the time will put you and your witness, who's in your hand in cross-examination, in a conflict zone. That conflict is not going to benefit you. We try to now explore another possibility. I'm trying to rush away because this is a very long topic, and to cover it within an hour or so will be a very difficult scenario. Now, when I say don't exaggerate, then I have necessarily to refer to two sort of cross-examinations. One is a brief cross-examination, and second will be a long cross-examination. A brief cross-examination is when you know what is your, that is the reason why when I said point number 1 and 2 about the mastery of the case and building up your own story. A person who's doing the cross-examination and who has mastery over his facts, and also he has his own story which he has to probabilize, he will be very clear in asking the questions, and his cross-examination will be very brief and very crisp. He will be asking the relevant questions, getting the answers to those relevant questions to his understanding, and the moment he gets the answer to his liking, which fits in his story, which fits in what he intends to project, then he stops there. He won't ask even one irrelevant question, or he won't ask anything which is not required or necessary to ask. We have many advocates I have seen in different trials in Jammu and Kashmir, in Punjab, in Delhi, in many other states where I have done the trials. The best criminal advocates are those who do very brief, very short, and very crisp cross-examination. They won't indulge into very long cross-examinations. But brief cross-examination absolutely means, in clear terms, that the person who's asking the question is truly and really the master of the facts. He covers whatever is required to be covered, and he doesn't leave anything. Briefness of the cross-examination doesn't mean that he leaves the things which should be asked. He should be 100% on asking the questions which are relevant, which are important to carrying up his story forward. The second type of cross-examination will be a long cross-examination. A long cross-examination is where the witness will be subjected to a very long cross-examination, maybe in cases running into days. A long cross-examination will usually be a cross-examination where one relevant question is hidden amongst 4, 5, 6 irrelevant or if not totally irrelevant, or a questions which are very innocuous, which you may not need it. If you want to ask a witness whether he was present at the point of time when the occurrence is taking place, if you ask him plainly whether you were present or not, he'll say, yes, I am present. So you start asking him many questions, 5, 6, 7 questions on the peripheries, taking him in the peripheries, that testing what was the time, where he was, who was else at the point of time there, from where he has come, where he has gone, everything. Now these questions on the peripheries is ultimately to bring him to one focal question, one important question. But you have in your mind this built up, that I have to reach there. But as I cannot reach in a straight line, so I have to take rounds. But you take round only to reach ultimately to the point where you want the witness to be taken. A longer cross-examination without meaning, without being meaningful, is absolute catastrophe. Don't do it ever. If you are indulging into very long cross-examination, but the purpose of the cross-examination is not even known to you, and you are only sitting with the hope that maybe something relevant comes from the witness in answer to a question which is being asked to him, and then ultimately you build up a story at the time when the arguments will start, it is never going to pay. You have to choose. It is your choice. It will depend upon your personality. It will depend upon the way you ask the question. It will depend upon your communication skills, whether you want to be an expert on brief cross-examination or you want to be an expert on longer cross-examination, but choose very wisely. My advice to you will be, that is my experience, that we have to choose between two of them. Don't become too brief cross-examiner and don't become too long a cross-examiner. Choose between two. That will be always helpful. Now I'll then try to connect it. That what is the practical aspect of it? See, whether you are into a brief cross-examination or a longer cross-examination will also depend upon your witness who's being cross-examined by you. There are again two ways. I'll say three ways of communicating with the witness. A cross-examiner can choose to be friendly with the witness. And by being friendly with the witness, he will be in a position to extract more than the witness will be willing to tell him. That is one way. Many cross-examiners, they adopt as a matter of strategy to be friendly with the witness. They make witness very friendly, very comfortable. And during that comfortable and friendly zone, the witness is more than willing to give the information which he may be hiding also. He may not be otherwise willing to divulge. That is one way. The second way is you bulldoze the witness. You try to fight with the witness and try to get the information, the fact which you want to get. No, this part will depend majorly upon the nature of your witness, the behavior of your witness. There may be some witnesses who are just not telling you truth. They are hiding truth, and you know it very well. They are hiding truth, but you have to take them out of their shell. One way can be to be friendly with them. But a witness who's very clever, or a witness who's what you can say, a professional witness type, a person who has come to the court not many times, he will understand that you're making witness very comfortable, very friendly, is only to get the information from him. Maybe you have to then put some pressure which is legally permissible upon the witness to get the truth from him. That is another style. You can adapt to that also, because your commitment is not only to your client. Your commitment is to the system. Your commitment is to the justice delivery system, that every aspect of the matter which should be known to the court, every information which is required by the court to write a judgment, should be made available to the court. A third way of dealing with the witness is to enter into communication. You don't become friendly, you don't become a bully type of cross-examiner, but you enter into conversation. And during this course of conversation, you give the feeling to the witness that he's very important, he's very intelligent. And if you give that feeling of pump up to the witness, he will be too happy to divulge many things which you probably cannot get out of him being friendly, you cannot get out of him by bulldozing him. So, what is sought to be conveyed to you is that you have to understand the psychology of the witness, you have to understand his behavior, you have to understand his intellect also. Unless you carefully study the witness, you will never be in a position to understand how this witness can be approached. And my experience in the profession tells me that whenever a witness comes to you, the most important tool a cross-examiner has in one-to-one interaction with the witness is the eye contact. Don't lose that contact even for a single moment. If you don't lose eye contact with your witness even for a single minute, you will understand it very clearly. And I can vouch for that. You can understand very clearly when the witness is telling lie. You can understand very well that when this witness is hiding something. You can understand very well at what point of time this witness has some information, some additional information which will be useful to you. Because your eye contact with the witness, please maintain that eye contact. Look to his face. That is, this part of it is science. Rest will be art. It is, we call art of cross-examination. We don't call science of cross-examination. But this part of it is purely science. And be very categoric and be very sure about this, that a person who's telling lie, a person who's hiding truth, will fumble. His face expression will change. That is the whole concept of the science of detecting the lies. When you tell lie, when you hide information, your body is not under your control 100%. You may be telling lie, you may be speaking untruth, but your body will reflect upon the person who's watching you that here is the point where the witness is not telling me the true information. He is hiding something. So maintain eye contact, watch very carefully the witness, watch very carefully his facial expressions, watch very carefully how his body is moving, behaving at the time when the cross-examination is taking place, and you will have more than 75% of your questions ready at that point of time, which will give you the quick results only by watching. I add a thing into this. Please don't look to any pro forma questions. There may be many books which may be indicating to you that these are the pro forma questions to be asked to a doctor, to an investigating officer, to an eyewitness, to a circumstantial evidence witness, to a recovery witness, to an informant, to a hearsay witness, to a relative witness, everything. The books will be filled with this. Just ignore them. No two cases can have same questions, because no two witnesses will be same. No two facts of the case will be same. When facts cannot be same, when witnesses will not be same, then to expect that the questions can be same is absolutely doing cruelty to your client, to the system, to the whole system. Try to build up your questions. Only two ways. Only two ways are possible. One, master the facts of the case, and with that, try to build up your story beforehand. Start filling the gaps into that during cross-examination. And number two, watch your witness very carefully. If you don't watch your witness and intend to do the cross-examination, not possible. That is the reason why this whole system of online cross-examination is failing. Online cross-examination never delivers, because your eye contact with the witness is not there. Without that, the difficulty will definitely be there. Now, then we come to that what is the purpose of getting the cross-examination? Is it because that is we have to understand that not many advocates they fault on that. Is it my duty towards my client to extract some information from the client, from the witness, which is a half information, only because I want my client to win the case? I ask question where I get the answer to the question which is different to the perception of the witness, but different as we understand. Please understand, witness is not an expert. In most of the cases, he's a commoner. You and me as liar, we have different perception, we have different story. The witness may not be knowing how his answer is going to fit up ultimately in the big story. But I have clarity in my mind, this answer I'm going to use this way. But if I win a case by causing damage to the system, if I win a case for my client, but make the system lose, that will be not doing justice to this noble profession of advocacy. You are paid by your client, no doubt, but you are paid by your client to say something which your client wants to say. But because he is not an expert, he is not in a position to say. But at the same time, you as an officer of the court has also a duty towards the court that you don't tell lie to the court, or you don't project a story before the court which as per you is not a correct story. Then I'll come to another aspect, very important. I'll try to cover now very quickly. A cross-examiner, biggest tool. Firstly, you understand, cross-examination is a tool in the hands of an advocate to extract the truth. And you know how tools can be used? The same tool can be used for good thing, and same tool can be used for bad things also. You have razor in your hand, you can probably shave your face, and the same razor can be used to shave off your head also. A cross-examiner's biggest tool is to understand when he has to stop. More than asking questions, the cross-examiner should know when to stop. I have the experience of about 35 years doing criminal trials and looking to very good cross-examinations, which just went bad only because the person who was doing the cross-examination couldn't stop asking the question when he got the answer. If you get answer to your question which is desired by you, then to ask more questions in that direction only to get something more is going to damage you. If you don't know when to stop, then you cannot be a good cross-examiner. Many times when you get an answer to a question and then you ask another question, the witness then explains everything and take away whatever has been given by him. Because the second question will give space to the witness. It will give the time to the witness to think over it, that whether the answer which has been given by him was right or wrong. And in that explanation, you will take away whatever has been given to you by the witness. Then another important aspect, before then I take the audience to the two important aspects about what is the interested witness and what is to be done with the hostile witness, because then we try to cover it up. It's already much time. Don't fight with the witness. And I'm very categorical. Don't hit the witness unless you have the proper ammunition. If you are hitting a witness and asking a pointed question, you should ask the question only if you have the enough ammunition with you. Asking a question and then don't have, and if you don't have the ammunition with you, is going to make a huge dent in your own case. See, what is the difference between cross-examination and in chief, examination in chief? Probably what has been, may have been told to you, or you may have studied that also. The biggest difference is that in cross-examination, you can ask a leading question. A leading question is a question whose answer can be in yes or no form. And in cross-examination, you can ask a question which can test the character of the witness also. Like a witness comes to the court and asks the witness that, is it true that you were not physically present at that point of time at the scene of the occurrence, but you were somewhere else? Now what he'll say? Say, no, I was there. I was there. I watched with my own eyes the offense taking place. And a cross-examiner stops here. Now what he'll do? He is probabilizing everything against him. But if as a cross-examiner, I have the evidence with me that at that point of time, the person was not in city A, but he was in city B. And I ask him that, is it correct that you were not there at that point of time? He said, no, I was there. Then I will confront him that this is the evidence that you were not in city A where the crime has taken place, but at that point of time, you were in city B. How is it possible that you can be at two places? So if I have the ammunition with me, I can fire from the ammunition. If you don't have the ammunition, don't hit the witness. Because if you hit the witness, the answer he will give will be hitting your case more harder. Then two aspects quickly looking into that, what is this whole concept of interested witness? Because we understand the legal proposition that evidence of interested witness is to be seen very carefully, that there is always a doubt in the mind of the judge whether the interested witness is saying truth or not. Two things we have to understand in this context, that who is the interested witness? And if a witness is an interested witness, how to cross-examine him, and what will be the aspect the court will be looking into an interested witness. See, interested witness is not a person who's related to the prosecution or related to the victim. That is an entirely different concept. A related witness is not interested witness, though in some cases it may be. But an interested witness is a witness who has the reason to depose falsely against the accused. If I have enmity and animosity with the accused person, I may have reason to depose against him, even falsely. That's the reason. the law is that the statement of the eyewitness, statement of the interested witness has to be seen with very carefulness. And if a person is proved to be an interested witness, the court will also always be looking into his statement with little doubt unless he clears everything. Because if I have a reason of being having animosity or enmity with the accused, I will naturally be interested in outcome of the trial in a particular manner. That is what makes me interested. I am interested in looking to the conviction of the accused. If I am interested into conviction of the accused because of my enmity, then my statement has to be looked into very carefully. Please, if a person, but this will not apply to a relative of the victim will also be interested in the outcome of the trial. He will also be interested in having the accused person convicted. But his reason of conviction is that he is interested in the victim getting the justice. Interested in the victim getting the justice and interested in the accused getting the conviction are two different aspects. So a person who's interested against the accused because of animosity, because of enmity, because of having some dispute on the property or any other thing, or maybe a personal dispute also. So he will be interested witness. The court will be looking to his statement with a greater caution. Now, what you have to do in cross-examination with the interested witness is you have to bring up that aspect which makes the court doubt whether this person will be deposing to the court in a truthful manner, or he is deposing only because he is having enmity, animosity, ill feeling towards the accused person. The whole cross-examination part will be interested in this, in understanding or probabilizing or putting it up to the court that there are bad relations between this witness and the accused person, number one. Number two, that he is deposing before the court because of those bad relations, because he wants the accused person to be convicted falsely. That is what you have to probabilize. Now, there will be another aspect. What to do with a witness which is a hostile witness? What is hostility? In what cross-examination to be put to the hostile witnesses? See, an hostile witness, as we understand, is a witness who deposes against the person who's bringing him as witness. Like in criminal trials, a witness who is brought by the prosecution to depose against the accused person. In the court, he takes a U-turn. He goes against his statement which is recorded during investigation by the police. Because in the police, the statements will be recorded of the witnesses. Statements can be recorded under section 161 to the police officer, 164 before magistrate. Now, if a witness deposes against his statement which is recorded under 161 or 164A, then in that case, the prosecution has got a right to ask the court to declare the witness as a hostile witness. It is not in all cases that the court will be declaring the witness as a hostile witness only because the prosecution is asking. If the court is satisfied that the witness is deposing against his recorded statement, the court will be declaring him as a hostile witness. Hostile to the person who's calling him. Now, hostility by itself will not create a doubt about what is being deposed by the witness. The court will again be very careful that this witness who's telling to the court what he has not told to the investigator, what to believe, what not to believe, that will be subject to the cross-examination, that will be subject to his witness before the court. Now, to a hostile witness, once he is declared as a hostile, the right is given to the person who is calling him as a witness to cross-examine. That is the only right which is given. Normally, the right of cross-examination is of the person against whom the witness is deposing, that is an accused, for prosecution witnesses. But if a witness is declared as a hostile witness by the prosecution, then prosecution will have a right of cross-examination. Now, what he gets additional as cross-examination as a hostile witness? The cross-examination of a hostile witness will mean that prosecution has got a right to ask him leading questions. As I said, leading questions whose answer can be given yes or no, which leading questions otherwise are not permissible. It is not permissible to be asked in examination. You cannot ask a leading question to your own witness. But you will be permitted to ask leading questions to your own witness if he is an hostile witness, because you have got the right of cross-examination then. In cross-examination of a hostile witness, the cross-examination will be limited to finding the reason why the witness has gone hostile. A prosecutor in cross-examining a hostile witness will find the ways to narrate to the court that the witness has turned hostile because he wants to help the accused person. Number one. Number two, there is pressure from the accused person. Number three, there are attending circumstances why he's afraid of telling the truth. Now, this cross-examination of the hostile witness will be giving an opportunity to the prosecution to project that the witness has turned hostile in the court, but he is a witness, depose something else to the court, to the investigation, and that his statement which has been given to the investigation is a probable statement which is still to be believed, even if he is declared as hostile, or some part of it can be read. I've tried to cover as many aspects as we could probably do in an hour's time, but I'd like to take the questions on this. I know there are many questions like a witness to the confession, a witness to the disclosure, a witness to the circumstantial evidence, maybe an eyewitness. There were lot many things. Simranjit Singh ji wanted me to discuss, but the time of 1 hour is just too short.
I understand, sir. Still, thank you so much, sir, for actually
because I'm looking to questions, but they are passing many very fast. If you can put me some questions, I can answer.
Yeah, sure, sir. We'll take at least 2 to 3 questions so that
please go ahead.
Okay. Sir, one of the question is, to what extent should we mold or assume the facts of the case in a cross-examination?
See, cross-examination, please understand, you have to be as close to truth as it is possible, in the benefit of your client and to your duty towards us, to the system. You should be as close to the truth as it is possible. Don't go too far away from the truth. Don't mold the facts. Mold the facts only to bring out the truth. Don't mold the facts to bring out a false story. That is not going to help anybody.
Okay, sir. Sir, if the witnesses, it's one of the question that if the witnesses are purchased and the prosecution knows that, but the evidence is not appropriate to prove the same thing. So how can the justice be delivered on that part?
If the witnesses are purchased, if you want to say that by the accused person, then a witness coming to the court will be declared hostile. A prosecution will be in a position then to get the witness declared hostile. And if a witness is declared hostile, then the prosecutor will have the right to cross-examine the witness to prove that what he has deposed in the statement to the magistrate or to the police is a correct statement, and that statement is to be believed.
Okay, sir. Sir, in what circumstances would the court allow a narco analysis test of a witness?
In what circumstances?
The court allows the narco test analysis of a witness.
See, actually, the difficulty is that there was a dispute whether a person can be subjected to narco test. There were earlier judgments which says that it can be done. Then the Supreme Court judgments came and said that nobody can be forced for the narco test. So now the position is that you have to ask the accused person if he agrees for the narco test, only then he will be subjected to the narco test.
Okay. So last two questions we'll take and then we'll wrap up. So what about the confessions made by the co-accused? Will it be binding on the accused person?
No, no. A confession which is made by a co-accused will not be admissible against the other person unless the co-accused is given a pardon to become a witness. If a person is given pardon to become a witness, then he can depose against his co-accused. What, like if there are 4 persons who have jointly committed a crime, and because the police doesn't have the witness against any of them, so what police will try to do is find out the person who's least involved and give him a plea of pardon that if you tell us the truth, then we will not get you convicted. So that person will come to the court and say that I'm also involved. But these 3 persons are involved and these 3 persons have said these things, they have done this thing. I have been given the pardon by the police, the assurance by the police that I'll not be convicted. Then that person, his statement can be read against the other accused. But if the person is not put as an accused, then his statement will not be read.
Okay, sir. Last question for today, sir. So what if the witness is a child witness and he turns hostile during the cross-examination? So what will be the procedure ahead?
He turns hostile during
The cross-examination.
See, so far as the child witnesses are concerned, firstly, the court has to satisfy itself before his statement is recorded that the witness understands everything and he's a competent, a fit witness to depose before the court. If after doing that, his statement starts and in chief, he supports the prosecution, but during cross-examination, he becomes hostile. The law is very clear. Even during cross-examination, the prosecution can say that please declare this hostile. Hostility can be declared in chief also, in cross-examination also. Even during cross-examination, because otherwise what will happen? A clever witness will support the prosecution in examination chief, but when he is cross-examined, he will change side. He will support the defense. Now, under the law, a person who is subjected to cross-examination and he changes the side, he then starts supporting the accused person. The prosecution will have the right to get him declared as a hostile during cross-examination also. And then he will be subjected to cross-examination by the prosecution.
Okay.
And whenever a person is cross-examined by the prosecution, after getting him declared as a hostile, please remember, then the other side will still have a right of cross-examination. Even after cross-examination by the prosecution, the other side will still have a right of further cross-examination.
Okay, sir. Understood. Thank you so much, sir, for such an insightful session and throwing light on the art of cross-examination.
I'm sorry for temporary interruption
No.
for 2 minutes.
It's completely fine, sir.
But the topic was too big, so maybe some other time we can continue.
Yeah, we can continue with the. Yeah, thank you so much, sir. Thank you so much. Thank you so much, everyone, for joining with us. You can give your valuable feedback on our various platforms. We'll wait to hear from you all. Thank you so much, everyone. That would be all for today.